Hi, my name is Dayna Zolle, and I'm Appellate Counsel at the Constitutional Accountability Center in Washington, D.C. I'm here to talk about a case that the Supreme Court heard oral argument in this morning called Cedar Point Nursery v. Hassid. And the case involves a challenge to a California regulation that allows labor organizers to access corporations' farmland for certain periods of time to organize and recruit labor workers to join those unions. And the regulation that's being challenged in California specifically limits the number of organizers who can visit the farmland. It stipulates that they can only visit during non-work hours and during a certain number of days each year. And it only allows visitors to visit places to visit certain places on the property, like where the employees are taking their lunch break. It also specifically forbids conduct that would disrupt the property or business operations. Nonetheless, two corporations brought suit in this case, challenging the regulation on the ground that it violates the Takings Clause of the Fifth Amendment, which provides that private property shall not be taken for public use without just compensation. Those corporations argue that the California regulation effectively takes their property because they lose the right to exclude people from it. And they argue that the court should rule that this kind of taking is categorically or always an unconstitutional taking, or a taking per se. The courts below rejected that argument. But here's the thing, the Takings Clause of the Fifth Amendment was originally understood to apply very narrowly, only to direct physical takings of private property, like when the government exercises its eminent domain power and takes private property to build a road or a park. The framers of the Constitution, including James Madison, who actually wrote the Takings Clause, viewed it very narrowly. They viewed it in this way, to apply only to the direct taking of private property. And for years, the Supreme Court held that it only applied to those physical takings of property. But through the years, the court has expanded the scope of the Takings Clause. It's held that it can apply to regulations that go too far, that are essentially the equivalent of a direct physical taking. So one example of a regulation like that would be a regulation that caps the height of buildings so low that it effectively renders a building lot entirely useless. The Supreme Court has recognized two types of categorical regulatory takings, or regulations that are always takings under the clause. The first is regulations that allow for a permanent and continuous invasion of private property, like when a landlord is forced to install a cable box in an apartment that's essentially always there. The second type of regulation that the court has held is categorically always a taking is one that drains the property of all economic value, like the height limit example I just mentioned. And if neither of those categories applies, the Supreme Court has held that there can still be a taking under a balancing approach that the court described in a case called Penn Central. But what's interesting is that the late Supreme Court Justice Scalia, who claimed to be a textualist and an originalist, and that means that he talked about always prioritizing the Constitution's text in the original meaning of the Constitution, was the one who most expanded the Takings Clause. So he wrote some of those decisions saying that the Takings Clause now no longer just applies to the direct physical taking of property, but it can also apply to some regulations that go too far. Justice Thomas, on the other hand, who's also a self-professed textualist and originalist, has recently called upon the court to go back to the original meaning of the Fifth Amendment and ensure that its decisions about the Takings Clause are grounded in the original meaning of that amendment. So we, CAC, filed an amicus brief in this case that argued that even though the court has expanded the Takings Clause scope through the years, under the original understanding of the clause, and even under the court's current precedents, the California regulation in this case does not affect a categorical taking. So that means it's not a taking per se, which is what the corporations say it is. It does not physically take any property. It does not affect a permanent and continuous invasion of private property, and it does not deplete the property of any or all economic value. The regulation is limited specifically to avoid those consequences. It specifically says that union organizers who are visiting the property cannot disrupt the business operations and therefore cannot deplete the business's economic value or the property's economic value. So the argument this morning was interesting. A number of the justices seemed to agree with parts of our argument that the corporation's argument is flawed, essentially because if you have a categorical rule that if this regulation, that this type of regulation allowing government access is always a taking, then that would seemingly render unconstitutional all kinds of regulations that allow access to private land for things like safety inspections that don't provide compensation. So essentially, if the corporations are right here that this is a categorical taking, then all kinds of regulations allowing basic safety inspections of things like nuclear power plants or mines could seemingly be held unconstitutional if they don't provide compensation for allowing that government access. But some of the justices kind of pushed back against the other side too, and suggested that they want a clear rule. They suggested that both sides here seem to have line drawing problems. They argued that some of the justices suggested that California's argument is flawed because saying that this type of limited access is not sufficiently permanent and continuous enough to affect a taking doesn't really give a clear rule for the court to apply in future cases. And a couple of justices, Justice Kavanaugh in particular, seemed to suggest that they wanted to apply a different rule entirely, one that came out of a case that didn't actually directly implicate the takings clause, but instead dealt with unions' rights and property rights. And he suggested that under that case, a case called Babcock, the corporations would win. I didn't really expect that case to come up. It wasn't really something that the parties had briefed or gotten into in this case previously. But nonetheless, it seemed that Justice Kavanaugh and perhaps other justices might be inclined to apply that case and see where it goes. So this is going to be a really interesting case to watch. It stakes unions against corporations. And really what it hinges on is rule of law. Does the Constitution, say what it says about this needing to, about the taking of physical property being what's at stake under the takings clause? And how much do we care about that text of the Constitution and the original meaning, which said that the takings clause only applies to direct physical appropriations of property, or essentially the equivalent of those kinds of direct takings of property. So again, it'll be interesting to watch. It was definitely an interesting argument, and thanks so much for tuning in to hear more about it. If you'd like to learn more about CAC's brief in this case or our work in other cases before the court, please log on to our website at www.theusconstitution.org. Thanks so much.